Good morning and welcome to the Judicial Committee of the Privy Council. Today we're hearing the appeal of Kelvin Duncan and Ramdath Jokhan against the Attorney General of Trinidad and Tobago. The issue in this appeal is whether the appellants, who served over 2 years longer in prison in Trinidad and Tobago than they should have, due to an error made by the Court of Appeal in their criminal proceedings in 2001, can now, after their release from prison, obtain compensation for that extra period of time served by a direct claim under the Constitution of Trinidad and Tobago. The appellants appear by Mr. Anand Biharilal, Queen's Counsel, leading Mr. Josh Hitchens, Ms. Sian McGibbon and Mr. Kenneth Thompson, and the Attorney General appears by Mr. Tom Poole. I am Lord Briggs. Sitting with me are Lady Arden.
Good morning.
Lord Sales.
Good morning.
Lord Hamblin.
Good morning.
And Lord Leggett. There will be a short break at or about 11:45. Mr. Biharilal, if you're still speaking at that time, please choose a convenient time. Just a 5-minute break to ease the eye strain caused by lengthy periods looking at screens. And for counsel's assistance, all the members of the court will be using the electronic bundles and will therefore be assisted only by the electronic pagination. Although if either of you are using paper, the other of you may wish to provide some assistance on the paper pagination. Yes, Mr. Biharilal.
My Lord, I'm very grateful. May I start by offering my congratulations to Tom Poole. I understand his name featured in the recent Silks list, and I hope the ceremony is called on as soon as possible in these current times. My Lord, I'm very grateful. Can I indicate at the outset that what we say is that when one applies the principle that an appellant or litigant is entitled to a system that is fair, if not infallible, we say that what took place here, resulting in the extra 29 months in custody, was a product of an unfair system. And we say that because no complaint has been made about the sentence of imprisonment or the time that the appellants had to serve. And no one has suggested throughout these proceedings that the 29 months was anything other than an excess period. We say that that excess period, as an indicator to a breach of the Constitution, is illustrated because that period was arbitrary. We say it was arbitrary because it depended purely on how long one would wait until one's appeal before the Court of Appeal could be heard. As some of the previous cases upon which the respondent relies and were considered by the Court of Appeal, that could have been 3 months, it could have been 5 months, or in an extreme case, as happened here, it was 29 months. Since there was no dispute that this was a period that, whatever the sentence imposed, these appellants should not have served, we say that that is the strongest indicator that the system that resulted in it could not be categorized as fair. We start our submission, my Lord, in relation to section 49 of the Supreme Court of Judicature Act. We've fully set it out in our respective cases, but it is perhaps important to look at the leading case on the subject of Ali versus the state. This is at the board's bundle, page 266. And I would invite attention to that now. And as I say, the principles are not in dispute. It's 266 at letter G on the left-hand side, where the board, in explaining how Section 49 was to work, required that the appellate court, in this instance the Court of Appeal, to consider in each case whether to exercise its discretion to backdate the sentence, and if so, for what length of time. And then this, the important part, the discretion should be exercised consistently and in accordance with the following principles, and the first principle being the making of orders backdating cases to the date of conviction should not be restricted to exceptional cases. That being so, again, no dispute that these appellants were entitled to have their sentences backdated, but that did not happen. It is notable that in the case of Ali, it appears the appellants in that case did raise certain constitutional arguments, one assumes in relation to the same right that is in issue in this appeal. And if I could invite the board's attention to page 271, at E, it's middle of the page. The board will note that in the judgment, Lord Carswell indicated each appellant also advanced an argument based on the provisions of the Constitution, though the focus of the submissions presented by counsel before the board was on other issues. And then on page 274 of the bundle, at C, last line, in making the orders on this particular appeal, the board stated it is accordingly unnecessary for them to consider the submissions based on the Constitution, which may be arguable, but they wish to reserve their opinion on them for a future occasion. And we say that this appeal now puts in issue those constitutional rights that are relevant, and it does arise now for determination in this appeal. So that the board has it, the same issue arose again in the board's decision of Bowler. And that can be found in the bundle at page, I'll take you straight to the actual relevant part. It's page 325 in the board's decision of the board versus the state, of Bowler versus the state. And it's the very last paragraph on 325, paragraph 25, halfway through the paragraph, where again, the board noted that suffice it to say, this particular appellant's appeal was not frivolous. But the important part is the second to last line. The appeal to the board on this issue was in truth here irresistible. And it is to the state's credit that Mr. Guthrie was in the event instructed not to resist it. And the reason we say that that is important is that when one now looks at what took place in this constitutional claim, there was no basis and never was a basis for the state to have said that the appellants should have continued to serve the entire 29-month period. And if they were not prepared to say that there was a basis for them to have to serve that time, their primary relief sought on the face of the claim, which was to release from custody, was irresistible. Now, my lord, I have set out in my printed case, and I'm not going to go to it in detail, but so that the board has it. We have referred to the Trinidad and Tobago Code for Prosecutors in relation to the duties of prosecution counsel, which is fairly standard even in England, that the prosecution counsel, as a Minister of Justice, is required to assist the court in relation to matters of sentence, the tariff, any guideline cases, and so forth. In this case, there is again no dispute that that did not happen. And so no attention, it seems, was drawn to the Court of Appeal by either counsel, prosecution or defence, that Section 49 needed to be considered. And whilst we accept that, the primary duty we would emphasise would have been that of prosecution counsel. And so that the board has the references, page 295 of the bundle. Paragraph 5 at the bottom of the page. Where Lord Wolfe, in this Attorney General's reference, set out in very clear terms the duty of prosecution counsel. Top of paragraph 5, it is part of the duty of prosecution counsel to draw to the judge's attention before sentence is passed any relevant guideline cases and to have copies available for him to look at if he or she wishes to do so. And my Lord, again, certainly the position in England is that it's fairly standard now, whether in the Crown Court or the Court of Appeal, whenever sentence is in issue, for both prosecution and defence counsel to put in a note in relation to it. But wherever the fault lay, it didn't happen here. And as a result, when one then looks at the relevant part of the code, which is at 226 of the bundle, and this is 226, paragraph 15.2, towards the bottom of the page. The prosecutor must seek to ensure that proceedings do not miscarry at a critical point and to protect the court from appealable error. And then immediately over the page, paragraph 15.6, this is bundle 227. Paragraph 15.6. The prosecutor must be aware of any legal limitations on sentence, including the maximum sentence, and whether the court has jurisdiction to impose any particular sentence. This assists the court to avoid appealable error. So it cannot be doubted from those references that the procedure set out in Section 49, subsection 1, following the decision of the Board of Ali versus the State, failed. It was, to put it in another way, a procedural error, because there's no complaint here about the actual sentence imposed. It wasn't suggested that it was either wrong in principle or manifestly excessive. And if that had been the sentence that... Forgive me.
I just wanted to ask whether the system is exactly the same now, or whether anything's been done to prevent cases falling through the cracks like this one did.
My Lord, the answer to it was addressed in the beginning of these proceedings in the High Court. It appears that the Court of Appeal now adopts a practice of backdating sentences following the decisions of Ali versus the State and Bowler versus the State. But that was the submission made as a support for the constitutional claim by the appellants in the High Court. I cannot assure the board that that happens all the time, or that it has corrected any cases where the direction was not given. But certainly it appears that that practice has now come into effect. The difficulty, which we highlight in our case, but which I deal with in answer to my Lord Legate, is that if the correction is not made, the attitude of the courts, as you can see from the decisions of the courts below, is that your remedy is to appeal to the Judicial Committee. And we say that that's just not satisfactory and doesn't render the system fair as far as this appeal is concerned. But certainly that was the reasoning adopted in the court below. So I hope I've given my Lord Legate a full answer.
Thank you.
Mr. Beharra, excuse me for just one moment.
Yes.
It may be that someone hasn't got their mute button switched on, which is causing a little bit of mechanical background noise. Thank you.
Okay. It wasn't I, my Lord.
No, well, you're speaking after all.
I have difficulty with mine, which keeps flicking back to mute. And there's often as I try to mute it, it then unmutes when I immediately turn to my laptop. So there is a problem, I'm afraid.
Yes. Well, thank you. I wonder if the engineers or the host can keep an eye on Lady Arden's screen to make sure the mute is working as well as it can.
Very grateful.
Carry on, Mr. Beharra.
So, my Lord, what it comes to, as far as this part of my submission is concerned, is that since there's no doubt as to the correctness of the decisions in Ali versus the state, followed on by Bowler versus the state, when those decisions were relied on as the primary grounding for the appellant's constitutional claim, we say that their claim was irresistible. Because, and we emphasize this throughout our submissions, there was no dispute that that further period of time from June 2009 was a period that these appellants ought not to have to serve. And that brings me, my Lord, to the pre-action correspondence, because we say this in our case, but we make it clear now. Had the respondent consented at least to the release of the defendants, the appellants, it would have still been open to the state to contest any order for compensation or any order for interest and costs. It did not mean that they had to adopt a hardened position that resulted in the appellants serving a longer period in custody. And for this, we would invite the board's attention to the record in a moment. But if I can take you to the chronology first, this is page 160 of our bundle. And we would invite the board to have in mind these dates for the rest of our submission. The 4th of June 2009 was the release date, the earliest release date, if a Section 49 direction was given. The 21st of June 2010, roughly a year later, was when the appellants issued their pre-action protocol letter seeking release. The 5th of July 2010 was the respondent's pre-action response, and the motion was issued on the 3rd of March 2011. Now, my Lord, and my Lady, the reason we draw this to the board's attention is that this entire period was during the period they should not have been serving. Because in the event, as you see from the further dates in the chronology, the appellants were not released until they'd served the full 29 months, 23rd of November 2011. Forgive me, Lady.
Could I ask you a question? In the letters sent making the claim originally, it was said there had been an application to the Privy Council which was rejected. Can you tell us when exactly that was?
My Lady, we don't have that date, and there was no evidence in relation to that date put into the record. But you are quite right, both pre-action protocol letters indicated an application for special leave was made and refused.
Would it have been immediately after the holding of the Court of Appeal?
I can answer that straight away. The answer would have been yes, and we say that that's a conclusion that is a perfectly proper one. The reason being, when you look at the chronology, the appeal was lodged the same day as the conviction of sentence to the Court of Appeal, so they were clearly acting expeditiously. And so it would have followed in 2001.
Yep.
Or at the latest 2002, because it seems they were anxious to try and progress it on the dates that we have. So it wouldn't have been, I suppose this is the important part, it wouldn't have been in 2006 when the board issued the decision in...
So there are two layers to go into the chronology. One is the application which was rejected.
Yes.
And later, maybe 5 years later, there would be Bowler and Alley.
That's correct. So the application for special leave certainly was issued and refused, but it would have been at a much earlier stage.
Thank you.
In relation to the pre-action...
I think Lord Hamlin had the question.
My Lord Hamlin.
So what is the evidence relating to that application being made?
There was no evidence adduced beyond the reference in the letter, my Lord.
Or where does the reference in the letter come from?
Well, my Lord, presumably from the instructions that were given from Mr. Thompson, who authored the letter. That was the only reference to it. It may be that, my Lord, I can develop the point further in relation to that, because I know that the point is made against me that evidence about indigence and so forth was not adduced before the board, and the respondent contests that contends that these are new points. But it may not be necessary for me to develop that, because as the board knows, following the board's decision of Hamilton, which we've included in the bundle, the board made very clear that although it was aware of the difficulties that arise, this is at the board's bundle, page 379. I'll take it in summary, if I may.
Are we going to a different point? I mean, if that appeared in the letter, it must have had some,
yes,
assumed evidential basis. And
yes, agreed.
I would have thought that would be in writing, but not.
Well, the normal course, my Lord, would be the application for special leave would be lodged, and if that was not granted, then you get an order from the registry indicating that leave has been refused. But it wouldn't have progressed beyond what would have then been the petition for special leave and then the order. The situation is different under the rules now, where you have other documents you need to provide, number of bundles and so forth before it goes before the panel. But it would have just been the petition, one document, and then the order from the board either granting or refusing leave.
Do we know what the grounds of appeal or grounds for seeking special leave were at that stage?
No, my Lord, we don't.
We don't presumably know whether the penny had dropped that an extra period of imprisonment was because of the appeal going to
No, and looking at some of the decisions that have gone to the board, it seems that the board considered it following consideration of criminal appellants appealing conviction. So, but looking at what took place before, certainly the application would have related to conviction and sentence, because that was contested, as I understand it, in the Court of Appeal.
We can't say, can we, that there was an application which failed the Privy Council to deal with this specific point?
I'm unable to make that submission, my Lord.
No, thank you.
But insofar as it may be of relevance, where the board hears an appeal against conviction, and there is a delay between, an obvious delay between the lodging of the petition and the hearing of the appeal, the board would have been empowered, as most appellate courts would be, to make any orders necessary to adjust the sentence appropriately. And so if it had come before the board, I don't think there can be any doubt that the board would have said, well, is this a case for making a loss of time direction if it was unmeritorious or not, and would have then affirmed the conviction and or sentence in that way. My Lord, can I...
We can't even assume that Section 49 was drawn to the attention of the Judicial Committee when the application was made.
No, I'm unable to make that submission because we don't have those documents, my lady. Equally, I can't say it wasn't either, but that's right. Can I indicate it follows from Lord Hamblin's question.
I think Mr. Poole may have something to say by way of assistance.
My Lord, I certainly don't want to interrupt my learned friend's flow, but I thought it may just assist, because it is a point that I will be making, addressing the point you're discussing at the moment. There's an explicit concession that an application to the board was not made, and that's recorded at paragraph 12 of the Court of Appeal's judgment, which is electronic bundle 126, where it's conceded that Mr. Thompson says that special leave to appeal to the Privy Council, the appellant did not attempt to do so. He contended in any event it was not an effectual remedy.
Thank you. Carry on, please, Mr. Beharda.
Very well. Paragraph 12 or 126. Yeah, I'm grateful. But in any event, can I invite the board's attention to the pre-action correspondence? And I'm going to deal with the paragraph 12 in a moment, but could I invite you to look at the correspondence, which is at page 27 of the bundle. In relation to page 27, the pre-action letter 21st of June, various references were made, but when you look at the fullness of the letter, the entire basis of the claim was set out in full, including this reference to special leave to the board having been applied for and not granted. But if you look at the last paragraph on page 28 of the bundle, the primary goal was the securing of the release from prison. What followed after, we say, is impossible to understand. Because when you look at page 30 of the bundle, which is the respondent's pre-action in reply, the respondent, contrary to what we say is the normal practice, doesn't set out any basis at all at that stage as to why the appellants ought not to be released. Boldly asserts that, assuming the accuracy of the facts, it's an abuse. And notwithstanding the authorities, there's no breach of a constitutional right. And the last line, the early release of your client does not arise on the facts. And we say, my lord, that that is extraordinary. Because if there was a basis, for example, to suggest that even at that late stage, the proper course of action was to even then petition the board for leave, one would have expected that it would have been set out in the letter. There's nothing like that. There's no explanation at all for why the respondent is taking objection. It may be worth noting that in the case of the appellant Duncan, it appears he wrote approximately 3 months earlier, but got no response from the Attorney General. And what we say, insofar as this is important for our submission, is that where the appellants had set out substantially their primary remedy of immediate release, it was incumbent on the state, because this does concern liberty of the subject, to have considered the claim properly and set out a considered response, indicating if it disputed the claim, and if so, on what basis. And if there was an alternative course, for example, to seek at that stage special leave to the board, then they could have said so, and perhaps have even indicated that they would not oppose leave being granted at that stage. It would also have had a direct bearing, my lord, as to what evidence was adduced on the claim. Because the way in which the pre-action correspondence works, as the board will see from what's in the record, is that you are required to set out in your pre-action letter the entire basis of your claim so that it can be properly considered. And had they indicated why they took objection, it may have impacted on what evidence was going to be adduced when the claim was ultimately filed. And my Lady Arden asked the question about the details of anything that may have been submitted to the board prior to 2006. And with the reference in the letter, it may have been possible at that stage to locate the documents to provide that to the respondent if they had taken issue about it. And this is why when my learned friend, Mr. Poole, quite properly took the board to page 126 of the record, I would invite you to look at page 126 again. Paragraph 12. Because we don't have a transcript of the Court of Appeal, but it appears that this occurred in the course of oral submissions, where Mr. Thompson conceded the appellants could, with special leave, appeal to the Judicial Committee and did not attempt to do so. But it's not clear whether that's not an attempt to do so at the time after Arley and Bowler, or in 2001 or 2002, and the position doesn't appear to be clear. And that may be important because if what was being suggested is that following the decisions of the board in Arley and Bowler, that an application for special leave might have been made at that stage, well, that may be right, but it's not possible to say that no application was made at an earlier stage, which may not have referred to section 49(1). I'm very grateful to my learned junior. Mr. Thompson is in Trinidad watching online. And he's confirmed his instructions to me that he acted on the instructions as far as the pre-action protocol letters were concerned in referring to the application for special leave, which may assist. But he did not have the documents at the time he issued the claim. So, my lord, in relation to the pre-action protocol correspondence, we say that it is important for the board to look at that with scrutiny, because it must have been, we say, the duty of the state, if they were going to take issue with their early release, even though there was no dispute they ought not to be serving the time, to set out why that was. And they singularly failed to do so. And we say that that is beyond doubt when the board considers the decision in Ramanoop, which I would invite the board's attention to now, page 317 of the bundle. And if I could take the board's attention to paragraph 33. Now, of course, we accept that many of these remarks by the board may have related to different points overall. But when one looks at what is said, their lordships add at paragraph 33 that it is in everyone's interest that an applicant should be in a position to decide which procedure is appropriate, preferably before he starts his proceedings, or failing that at the earliest opportunity thereafter. And then adding in Justice of Appeal Hamill-Smith's comments, the decision in Jaru's case also serves to emphasize, in my view, that the state must at an early stage, ideally in response to any letter before action, make it known whether it will be challenging the allegations or not, and on what basis. In that way, the agreed party would be in a position to make an informed choice of procedure. And my lord, we say that that must resonate with this appeal, because had the respondents indicated the basis upon which they were taking issue, it may have affected the position the appellants might have taken, that if the course they should have taken was an application for special leave, that might have been something they tried to do expeditiously, even at that late stage, even if an earlier application had failed. Because Section 49 and how it worked was then known. That was the basis of the proposed motion. They didn't do so. And where the detention of a person, I don't think there's any dispute about this, is certainly prima facie tortious, but also an infringement of Section 4A of the Constitution, it was incumbent on the state at that stage to say how the detention was justified. And for that, the board may already be familiar with it. It's the board's, Lord Clerk's decision in Ramsey, where in the context of a false imprisonment case, this is at 489 of the bundle, paragraph 8, subsection 1. The detention of a person is prima facie tortious and an infringement of Section 4A of the Constitution. And so when one is considering the issue of abuse, which I'm going to turn to now, there was nothing, forgive me, Lord Hamden.
Well, that's in the context of detention under a power of arrest.
Yes.
The detention was pursuant to a lawful sentence.
Yes.
The sentence remained lawful at all times. It was never set aside.
My lord, that is right, and I don't shy away from it. What I'm indicating is that the lawfulness of the sentence, again, has never been an issue. The period of time they were sentenced to was never a problem. It was the extra period, which was never to be part of that sentence, that was not justified. And so even when looking at, although Lord Clerk was there talking about arrest and detention in the common law context, we say that there's a natural extension there, that if as part of a lawful sentence, you then end up having to serve a longer period, which is not intended to be part of the sentence, then that must be prima facie a breach of the Constitution, because that is not what was contemplated by the sentence passed.
Well, can we take this in stages, Mr.
Yes.
Hammond? I quite understand your submission that the extra time served was unjust, as having resulted from a failure by a court of competent jurisdiction to avoid that consequence by making a specific order. But the extension which arose from the appeal to the court was one which was imposed by statute, Section 59, was it?
Yes.
So I'm in slight understanding how the extra time was unlawful rather than merely unjust.
If I can answer my lord in this way. Again, I don't think it's disputed that, or disputable, that when the board gives a decision as to what the law is, whether it's statutory or common law, that is taken to have been the law,
Yes,
going right the way back. And so I suppose my answer to my lord's question is that even then, if one goes back to 2001, when the sentence was affirmed and the Section 49 direction not given, because there's no dispute it ought to have been given in the appellant's favour, the extra 29 months could never have been accepted or contemplated as part of that sentence. It wouldn't have been part of the lawful period they would have to serve. I suppose that's the only answer I can give, my lord, on to your question.
Yeah.
But, sorry, my lord Legate.
Can you perhaps make something of the point you made earlier, that unless consideration was given to the possibility of not of backdating the sentence, part of the thing is simply arbitrary in nature, and could be argued to be unconstitutional for that reason.
Yes, I agree. And this is why I said at the beginning, this could have been 3 months. In Bowler, I think it was 3 months. It could have been 9 months. It could have been longer. And I mean, I'm sure this court is aware from the experience of the Court of Appeal Criminal Division in England. Sometimes it varies depending on how much priority a criminal appeal is given. If, for example, it relates to a very serious and sensitive matter, it can be moved up the list. And in Trinidad and Tobago, for obvious reasons, and there's no criticism of this, cases which involve homicide where the death penalty is passed would be given priority. And so cases like this, which are non-capital cases, that may explain why it took 29 months here. But even then, it's arbitrary. It could have been any period. It could have been longer than 25 months. But in any event, that wouldn't flow from section 49(1, because it still wouldn't have been dependent on them lodging an appeal, because once they'd lodged their appeal, their case goes onto the list. They have no control over it. My lord, in any event, we've drawn the board's attention to Ramanoop, and we say that unless the respondent was prepared to indicate how this claim was an abuse, it was wrong for the court to then go on to do so. And so that the board has it, where in Ramanoop, the board indicated that although it's preferable for the state to indicate their position before the proceedings start, they also say, failing that, at the earliest opportunity thereafter. But when you look at the record, and it's in the chronology, you can see that even when the claim was issued on the 3rd of March 2011, and if the board turns to, I can illustrate it with page 2 of the record, which is page 2 of the bundle. You can see when the claim was issued on the 3rd of March 2011, which attached the affidavits of Duncan and Jokhan, the defendant doesn't issue any counter notice or anything at all until the trial stage, where they issue their submissions on the 29th of June 2012. And by which time the sentence had been served, or the extra period had been served. Yes, my lord Legate.
I entirely understand your complaint about the state response to the how do you translate that into a claim which, according to the jurisprudence, seems to have to be based on some systemic failing rather than just an individual fault?
Well, my lord, if the systemic failing resulted, and we say it is a systemic failing if the period is arbitrary.
That's a separate point. I'm asking you now about the response to the pre-action letter and its totally unsatisfactory nature.
Well, my lord, the reason I say it's important is this. It has a direct bearing on how the claim may be framed. If in pre-action correspondence, the respondent indicated, look, these are the reasons why we say you don't have a claim here, it may have affected the action of the appellants. It may
I understand that, in fact, yes. But what's the legal arguments that you're making here?
Well, my lord, I suppose if I were to talk about a systemic failure, it would be a systemic failure in itself for the respondent to not properly engage pre-trial with a constitutional claim.
But that's just a one-off event on the face of it.
But a one-off event that had detrimental...
It's like the error made by the Court of Appeal. It doesn't in itself, according to the case, it's probably going to take us to independent.
Well, I'll try and deal with that in more detail, but I think my answer to my Lord Legate at this stage is that this was a systemic failure, whether one looks at the failure to draw the attention of the Court of Appeal to Section 49, the failure of the court to make it, or the failure of the respondent, now dealing with the response to the constitutional claim, to actually engage with the applicants who were serving a period that they were never going to dispute they ought not to be serving. I think that's the only answer I can give my Lord Legat at the moment, but I'll try and give a fuller one in a moment, if I may.
Does the, are you saying that the Court of Appeal's own failure in 2001 was systemic? It doesn't appear that this was a sort of one-off act, that nobody in the court, counsel on either side, nor the court itself, adverted their mind to Section 49. Was this something, and the evidence, I suppose, it's still available, must show whether this is happening on an almost daily basis or not at all?
Well, if the cases of Ali and Bola are an indication, my lord, it certainly appears not to have been confined to this case. It happened a number of times, and those who were fortunate enough to be able to bring an application for special leave to the board in criminal proceedings managed to. Oh, what's happened here?
We can still hear you.
Okay, sorry, you've disappeared from my screen.
Oh, sorry.
Sorry, come back. I'm grateful to Ms. McGibbon, who knows much more about computers than I do. Sorry, my lord, I was I didn't complete my answer. I can't.
Well, you were saying that it looks as if it happened on several occasions, judging from those decisions of Ali and the one that followed it.
Yes.
But I just don't know whether we're all thrashing around in an evidential desert or there's any basis on which we could draw conclusions.
What we can indicate, my lord, if the insofar as I can give the answer that this has happened on a number of occasions, the answer to that is yes. And I've given you the example of Ali and Bola, but it also appears to have happened in relation to another appellant called Desmond Wren, who did not, I'm afraid, succeed in his motion, which is at page 326 of the bundle. And it's page 327, perhaps the easiest reference. Page 327, bottom of the page, paragraph 3.1. Where in that case it appears another claim was made following a failure to make a section 49.1 direction. And so it appears, I hope this answers my Lord Salisbury's question, it certainly happened in Bola, Ali, and also in Wren, including for these appellants before the board now. So if the practice was, as it appears to be, not to make a section 49 direction for any appellant, criminal appellant, then it would have affected a great number of people.
And this Court of Appeal is presumably constituted of a relatively small number of senior judges.
Yes.
All of whom would presumably know each other. And if, and oh my goodness, we haven't thought about section 49 got around, one assumes it would have been fairly quickly condensed into some form of.
Well, one would hope so, but I think I can't answer whether in fact that happened in this case. What I do know is that certainly following the board's decisions in Ali and Bola, that it then seems the Court of Appeal started to make it a practice to consider section 49 because that was the decision of the board.
Yes.
But before that date, no, and the appellants before the board in this constitutional appeal were well before that time, going back to 2001, when their appeals were determined. So, my Lord, we say that, that there was nothing in the pre-action correspondence to indicate it was abuse. I've taken the board to Ramanuk, but now can I develop the point as to why the Court of Appeal and the High Court were wrong insofar as they may have construed the appellant's claim, constitutional claim, as an abuse? The constitutional motion procedure, I know the board is aware of this, so I can perhaps take it shortly. Unlike a regular claim, is much less costly to an applicant. And because it usually is very straightforward, you're claiming a breach of your rights, you set out the basis, and you put the claim before the court. The standard procedure is to issue a fixed date claim form, as occurred in this case, plus the affidavit setting out the consequences, the breach and its consequences, and that took place here. Ramanuk considered these matters in that decision, and could I invite the board's attention to page 316, which is the board's decision in Ramanuk. And what the board indicated, this is the top of the page, acknowledging, dealing with the continued misuse of the jurisdiction, is that proceedings brought by way of originating motion for constitutional relief are less costly and lead to a speedier hearing than proceedings brought by way of writ. From an applicant's point of view, the reason for seeking constitutional relief is eminently understandable. But then in the last line of that, proceedings brought by way of motion solely for this reason are a misuse of section 14. Now, what we say, my lord, pausing there, and my lady, is that this didn't fall into that category because the primary goal the appellants were seeking was release from custody. They ought not to have been serving. And so it was a bona fide resort to the constitutional motion process, and one which, if it had worked as it should, would have resulted in their immediate release in June 2010. And we say that because if the respondent had, for example, indicated, well, we certainly concede you ought to be released, it may very well have been that they wouldn't have pursued any further claim because they had secured the primary goal of release from custody they ought not to be serving.
Lord Leggett has a question.
Yes, sorry.
Difficulty, seems to me, with this argument is that it's a bit of a bootstraps argument, isn't it? But I mean, what is the basis on which release would have been ordered if everything had gone smoothly?
Declaration and release to follow from the breach.
A declaration, what was the breach?
A declaration that that their right to liberty and security of the person for that extra period of time was a breach of their constitutional rights, and therefore they were entitled to be released.
Well, for that, you have to develop the argument that it was a breach, not to have made the loss of time.
Yes.
Or not to have avoided the loss of time in the first place. And well, you can't, so to speak, rely on the subsequent event, which we've been emphasising.
Well, what we've said, I'm sorry, speaking over my Lord Leggett, what we've said is that where we rely on the decisions of the board in Ali versus the state and so forth, that indicates that they ought not to have been serving that period. Therefore, we say that it was clear any extra period they were serving was a breach of that right.
Well, you're going to have to engage pretty soon with the jurisprudence on what amounts to a breach in the systemic arguments and so forth.
Yeah. I will try to do so. Just in relation to this point on cost, my lord, and what I'm trying to show at this point is the bona fide resort to the constitutional constitutional motion process. In this particular case, if the board looks at page 95, you see an illustration of why this was the most effective course to secure the release of these defendants. because when you look at page 95, and it's very limited, this point, but an important one, you can see that the judge assigned prescribed costs for this case in the sum of $50,000. And again, not disputable. Once you assign that amount of money, which is a nominal value for the purposes of the claim, it caps the costs at $14,000 as pursuant to the civil proceedings rules. There is a scale there which is set out, which indicates that. So that's roughly about £1,500. And so this is why we say that the constitutional motion procedure was one, forgive me.
Were there any other domestic remedies that might have been available?
No, and I can answer my Lord Hamblin on that. We looked at this to see whether there was any available, but the approach the courts have adopted, both courts below, is that there was no domestic remedy, but you did have a remedy to seek special leave from the board. And so it wasn't even possible on their reasoning to go back to the Court of Appeal to say, well, will you hear me in relation to whether you can even at this late stage make the appropriate Section 49 direction. And that was rejected, it seems, by both courts below. So the only remedy available was that by virtue of special leave to the board. So the answer is no, except the constitutional motion procedure, which what we've tried to illustrate would have enabled them to get relief in a much shorter period of time. My Lord says.
Yes, I was just wondering whether in that context the response to the letter before action assumes greater significance, because it might be said that that was indicating that the state would offer resistance to an application for special leave from the board, which would be likely to occasion delay and create uncertainty about what the outcome of that application might be. And I wonder whether there's any scope in your argument for adding together the only remedy apart from the constitutional motion being an application for special leave with the response of the state to that in the circumstances of the case.
My Lord, I would adopt that reasoning. I would say that when you look at the very clear statement in the pre-action response, the early release of your clients does not arise. It showed nothing to indicate that even on an alternative basis, they would have been prepared to consent to the release of the appellants. And this is why we say that the pre-action protocol was so important, because if they said, look, it's not appropriate to do it this way, but it might be appropriate to do it another way, that's why you shouldn't bring this claim. They could have said so. And that would have impacted on the actions that the appellants could have taken or would have taken. But since the statements in the pre-action response was so bland,
but
they had no way to know what the abuse alleged was going to be.
But Mr. Beharla, a submission that the Attorney General should have replied to your pre-action protocol letter by saying, well, you should apply for special leave to appeal to the Privy Council, has to face page 28 of the bundle, which is the letter on behalf of Mr. Duncan, which says in terms he applied for special leave,
yes,
it wasn't granted. Now, I quite appreciate that there may be all sorts of speculation as to what was in the writer's mind about when that had been done. But all the Attorney General could see reading that letter was, well, we tried that one, but it was no good.
But then that's all the more reason why it wouldn't have been an abuse, my Lord, because having tried to use the remedy that was available in the criminal proceedings, which didn't succeed, the only option then would have been a constitutional motion.
I can understand that.
So it probably enhances the appellant's resort to the constitutional motion procedure rather than diminishes it. My Lord, the other aspect of this is that when one looks at the way in which the respondent dealt with this, and this may be of some importance to the point about special leave, the respondent's position in this claim was, one, not to dispute any of the evidence of the appellants, including the reference to special leave to the board, and two, not to adduce any evidence of its own on any issue. So they proceeded on the assumption that what was in the evidence before the High Court was correct. And that may have some great significance, we say, because when you look at the way in which the proceedings went ahead, what we know is that there was no oral argument before the High Court. This case proceeded, in effect, as a paper trial. So the parties put in their submissions, and the judge then gave a judgment subsequently. And I don't think there's any dispute about that, but in the event the board needs the reference, if the board can look to page 103 of the record, paragraph 4, this is Mr. Thompson's skeleton argument. The respondent filed no evidence in the claim, and therefore the learned judge had before him the evidence of the appellants alone. After considering the appellant's evidence and written submissions of the parties, the learned trial judge delivered his judgment on the 26th of September 2013. And so there was no concession before the High Court that an application for special leave had never been made. The evidence was that it had, and it didn't succeed. And that being so, it's difficult to see how the Court of Appeal could have then raised the question. One assumes the question may have come from asking, well, could they not have gone after the decisions of Ali versus the state? Well, maybe they could have, but by that time they'd already launched their motion and they were before the Court of Appeal. And so it would not have been open to the respondent to dispute the agreed evidence before the High Court, even on appeal. And I think I've identified where the confusion may have arisen, because the respondent's counsel in the courts below made a submission to the High Court. This is page 85 of the record. Forgive me, 84 of the record. And I think this is probably where this point may have become confused. If the board looks at page 84, paragraph 35, the respondent submitted that the claimants failed to make use of that process and seek leave to appeal to the Judicial Committee. But of course, that was the submission made against the background of the evidence that they never disputed. And it looks like that both the High Court and the Court of Appeal adopted that and simply accepted it when in fact the evidence was to the contrary. So that may be how that hare got set running, so to speak. But it wouldn't have been open to the respondent to do that unless they were going to challenge the appellants, the claimants as they were then, on whether in fact they had made an application for leave. And if they hadn't, to adduce some evidence, if they had it, to suggest that wasn't so. And so it may be that the board would wish to note that, because it looks like that error then crept in a little later, because before the Court of Appeal, the respondent did not file any skeleton arguments. They simply elected to rest on the submissions they made in the High Court and made some oral submissions to the Court of Appeal. And if that's right, then they'd exhausted their remedy, and that was the evidence that the courts should have proceeded on. My Lord, in relation to the respondent's reliance on Wren, both in the courts below and in this appeal, the distinction that can be drawn in Wren, or Rennie, which is at the board's bundle, page 327 and 328, is that since in this case, the appellant's case, there was no dispute that they had applied to the board and not got leave, there was a clear distinction to be drawn from the position of Rennie, who apparently confirmed very early on that he did not exercise his right to make an application for special leave. This is at the top of page 328 of the judgment, 328 of the bundle, top of the judgment. Where there, it seems to have been accepted that the appellant in that case, Mr. Rennie, did not actually try to seek permission to appeal.
Lord Sales has a question.
Sorry, just on the facts of this case, was he still in detention at the time, or was this a claim brought after the period of detention had come to an end, seeking compensation?
I think Rennie was after he'd already served his period in custody. But in relation to the appellants in this case, I think the board is aware we were still in custody when we issued the claim and issued the pre-action protocol letter.
Yes, thank you.
Now, my lord, the point is taken against me and was part of the reasoning in the judgments below in relation to promptitude, that the claim was not issued when it ought to have. It should have been issued much, much sooner. Well, quite apart from the fact that we didn't know, we didn't have the board's ruling in Ali and Bowler until 2005 and 2006, respectively, we say that in any event, the appellants cannot be said to have not issued their claim in time. And the reason we say that, my lord, and it dovetails with what I've just answered to my Lord Sales, this breach, we say, was an ongoing one. It was a period of time they were in custody that everybody agreed they ought not to be. And therefore, when they issued their claim, or certainly their letter in June 2010, having only served at that point 12 months in custody that they shouldn't have, it couldn't be said that they hadn't issued their claim in time and that it followed somehow that they should never be released. They were still suffering what we say was an ongoing breach. And I don't know whether this answers my Lord Legate's question. The breach we complain of is that here they didn't have the benefit of a Section 49 direction and so forth, which we've covered, but the respondents did not dispute that they should not have been in custody. They knew that when the pre-action protocol letter was written. They didn't dispute it when the claim was issued. And they proceeded on the basis, yes, you're right, you shouldn't have been in custody, but we're not going to consent to your release. And that being so, we say that the breach was well established on the respondent's own concession that they ought not to have been in custody. And as a result, where the breach was ongoing at the I'm sorry, my Lord Hamlin.
How do you suggest that would have worked? I mean, they were still serving a sentence imposed by a court of competent jurisdiction. And until that sentence was changed, that was the position of it.
My Lord, yes, except that, you see, this is where I'm perhaps drawing a distinction, which I don't know how attractive it is to the board. Where a criminal court passes sentence, it says, look, here is your 15 years as it was in this case. There is a degree of certainty as to how long you're going to serve. If, for example, in England, you're not found dangerous, you serve half and you are released on license. You know you're going to serve half of that sentence. If you're found dangerous, you know you have to serve 2/3 and then apply for parole. So you know that your release is not certain until you can apply for parole and satisfy the criteria. In this particular case, the prison rules, which we touch on in our case for the appellant, made clear that if you, once you were of good behaviour, you were entitled to the 1/3 remission. There's no dispute that these individuals satisfied that criteria. And in some respects, I suppose one could say that you wouldn't know that you satisfied that criteria for early release for good behaviour until you'd been of good behaviour, which would have taken you to almost 2009. But that being so, you would still have had to have the benefit of Section 49, so that any extra period between your conviction and your appeal was counted in your favour. In England, the position has been adjusted, where the judge may declare in a homicide case, for example, you've served 320 days in custody pending trial, that will be counted towards your life sentence with the minimum term, etc. But now, of course, Parliament has adjusted it for other cases where the calculation is made by the prison service pursuant to statute. We've made the point in our case that following the decision of Ali and Bowler, now that the state knew that they had that direction should be given, not exceptionally, but in every case, unless there was reason to make a positive loss of time direction, the state could have acted on that without anybody going to the Court of Appeal or the Judicial Committee at all, which was to simply say, we'll make an amendment to the prison rules so that anyone who has not had the benefit of a Section 49 direction shall be released in any event after serving 2/3, or the period between conviction and appeal will be counted as part of your sentence. That's all they needed to do in our submission.
All right, but looking at the response to the individual letter,
yes,
there's a sentence imposed by the Court of Appeal, 15 years running from the date of the appeal. That's the legal sentence. What exactly were the authorities to do? You say amend the prison rules generally?
Well, my Lord, I've suggested a way in which let me answer my Lord Hamlin in this way. If there was to be any remedy following the decision of Ali and Bowler, it had to be one which would apply to anybody who didn't have the benefit of a Section 49 direction who should have had it. There were ways in which that could have been achieved. I've suggested perhaps an amendment to the prison rules. That may not have worked, and I see my Lord Briggs may not agree with that, and that may be a bad point, I don't know. But the state now having been told by the board that this direction should have been made, it wasn't powerless to act. There were things it could have done to prevent any further litigation, either to the High Court or the Court of Appeal, if they had wanted to. But not having done so, we're in this situation, back to reality, where the only option, if it were an option, was an application for special leave to the board. And we say that going back, way back to the decision of Maharaj and the Attorney General, that in itself does not render the system fair. And whereas here it appears that they did try and failed, that unfairness is illustrated quite starkly. And there's an additional point we say of public. I'm so sorry, my Lord says.
Yes, it may be that I'm getting confused. If there were a breach of Section 4A of the Constitution, which was identified in the constitutional motion. Am I right in thinking that the High Court could have itself ordered released?
Yes.
Right?
Yes, absolutely. Yes, the answer is yes. And in fact, that's exactly what happened in Maharaj. It's often forgotten, although he was appealing his criminal contempt. When he managed to secure his release on bail, it was through the constitutional proceedings. So yes, the court is empowered to order release if it could do that.
Right, thank you.
And Mr. Baharlal, the reason I was perhaps rather rudely shaking my head about the amendment to the prison rules is this. The reason why the Court of Appeals not making a time served direction meant that his sentence ran for 15 years from the date of the appeal is set out in primary legislation,
yes.
Section 49.
Yes.
I'm in some difficulty in thinking how a mere amendment of prison rules, which I assume are by some form of legislation, could have any consequence on that.
Yes, I suppose the answer to my Lord Briggs' question is that if, having received the sentence pursuant to statute, as happened in this case, you're right, my Lord is right, the Court of Appeal is empowered to do that, it's a lawful sentence. We do know that the prison rules do make provision for early release, 1/3 remission.
Yes. Oh, yes.
And so when I looked at it, a similar course might have been taken, and again, I'm perhaps it's somewhat speculative, to address the anomaly where a Section 49 direction should have been given, and to make an amendment to the rules that brought that into effect so that the 29 months would have been discounted, so that they would have been released anyway. And it would have taken some creative drafting. But if you've already got rules that say, look, you don't have to serve the whole 15 years if you're of good behavior, it might have been possible to creatively draft the appropriate section. I'm saying it's an option. But yeah. I think what it comes to, my Lord, is this. From the moment the state had the benefits of the board's decisions in Ali and Bola, it was incumbent on them to at least recognise there were people in custody who ought not to have been there, including, we say, these appellants, at the very least.
Yeah.
And that wasn't done. And as we say, going back to what I was saying, setting out, this was an ongoing breach at the time they issued their claim. And so there couldn't have been any issue of delay or failure to act promptly, because if they had issued their motion in 2001, we wouldn't have had the benefits, and I'm being in practical terms, we wouldn't have had the benefit of the board's decision in Ali and Bola. So it may have been at that stage that their motion would have failed, because that was not understood to be the law.
Mm.
But now, of course, I'm so sorry, now, of course, that we know it is the law, when they issued their claim, as long as the state accepted the reasoning of the board's decisions in Ali and Bola, I just can't see how they could have resisted at least the declaration and the order for release.
And dealt with it as an early application for a quick hearing of a consent order.
Yes. Yes. To say we agree, and then you issue the draft would have been, here's a consent order, everyone agrees, and everything is issued simultaneously one day.
Yes. Well, now, Mr. Baharlal, we've been interrupting a great deal. We're into the zone for a 5-minute break. If you've still got a long way to go, we'll try and behave better thereafter.
I'm very grateful. I'd be grateful for a break, my Lord, if I may.
Thank you. We'll resume in 5 minutes.
Thank you.
Please continue, Mr. Baharlal.
I'm grateful. My Lord, Lord Sales asked me the question in relation to the decision of Rennie. I can be a bit more precise in when he issued his claim. If the board turns to page 331 of the case of Rennie, and it's paragraph 9, in that case, he had issued his motion some 4 years, it seems, after his release from prison. So his was only a declaration of compensation. And it's worth noting, in relation to this arbitrary period, he only served an additional 15 months in prison, before his, as a result of Section 49. My Lord, I hope this is answering my Lord Legate's question in relation to fairness and whether the system is fair. And what we say is this: the absence of an effective domestic remedy, except a constitutional motion to correct this, is indicative of a systemic failure. There should have been, but there isn't, a procedure by which the matter could have been brought back before the Court of Appeal, or perhaps the High Court, whereby the remedy sought could have been swiftly obtained. There is none. The position adopted in the courts below, and this appears to be right in law, is that once the Court of Appeal is functus, the only avenue is an appeal by way of special leave. And there's nothing in the judgments below or any of the reported cases to suggest that anything other than special leave could correct this problem. And that, we say, now turning to the Section 103 of the Constitution, it may be worth looking at. Can I invite the board's attention to page 260 of the bundle? Which sets out Section 109, subsection 3 of the Constitution. I, like many other barristers from Trinidad, would say that this is a highly prized section. And it states that an appeal shall lie to the Judicial Committee with the special leave of the Judicial Committee from decisions of the Court of Appeal, and as far as relevant, in a criminal matter. Now, what that indicates, insofar as it's relevant to this appeal, is that there is no right of appeal to the board, but you can make an application for permission to appeal to the board, unlike the position in the Court of Appeal where you have a right of appeal. It appears that that is in part of the problem, because the appellants could not get their case before the Court of Appeal to correct this anomaly. The judge at page 89 of the record may have misunderstood this. At paragraph 10 of the judgment. So it's page 89 of the record, paragraph 10, wherein setting out the position of the defendant indicated that the claimant could have appealed the decision as of right. Whether he did or he didn't may not matter, but the board may wish to note that, and also page 91, paragraph 17. Because at paragraph 17, page 91, the judge says, to return to the import of the timelines identified above, due process available to the claimant is the opportunity to pursue an appeal to the Privy Council as of right, or indeed to pursue this constitutional action before the High Court, and then relates that to promptitude. And so there may have been a degree of confusion on the part of the judge with section 109, subsection 1 versus subsection 3. Sorry, my Lord Legate.
is there any reason why special leave wouldn't have been granted if this point had been raised in an application?
Well, my lord,
leave?
the answer, I suppose, is that following the decisions of Arley and Bowler, once that had been set out in the application for leave, one would have expected the board to grant leave. The problem, however, is that if that was the course that ought to have been taken, and this is what we come back to, there's no reason why the respondent couldn't have said that that was so. And if, as the appellants set out in their letter, they had already tried that and failed, then we're talking about a second petition, a second application, which was not indicated as an option from the respondents either. And it's very rare, as I understand it, for a second application to succeed before the board where it has already refused leave.
But in principle, it can be granted.
In principle, and that may be, my lord, what the Court of Appeal was getting at in that discussion in the court below, that maybe they could have made an application after the decisions of Bowler. The problem is there would still have been no remedy available domestically in Trinidad and Tobago for the immediate relief, because then when we go to that, the option of applying for special leave, the procedure, of course, is different now than it was under the old rules. There are a number of things one has to do, and you have to secure a lawyer who is able to do that. There's no evidence here that they would have been able to secure such a lawyer, but maybe if the respondent...
That's quite good evidence, because they both, according to you, found a lawyer to make the first application, and then when they identified that they may be wrongly imprisoned, they found a lawyer to make a second one. So,
well, they've certainly found lawyers in Trinidad to file the constitutional motion. That's right. I mean, I've come to this rather late in the day, but I take my lord's point. I think the difficulty with that, though, is that whatever resources they would have had in 2001, 2002, it can't be assumed they would have had the same resources later on. But let's assume that they did. If the position adopted by the respondent is, look, you could appeal for special leave, and we would consent to that, but we're not going to consent to a constitutional motion because, for example, we don't want to have to agree to a declaration or compensation. Maybe that was the reasoning behind it. All they needed to do was say so. And then the appellants could have considered that course of action. And that's what Ramanuk goes to, my lord, that if this matter had been raised before, it would have given them something, another option, so to speak. But that wasn't even flagged as an option, and the entrenched position of the respondent is your release doesn't arise.
well, maybe at some point you're going to take us to the case that sets the test for having to have a fair system overall. But do you contend if that is that the only ground that the system overall is unfair, or can there be a special case where the individual facts or the circumstances are particularly unfair?
I would say both. I think that, you know, because each case has to be looked at separately, there may be unfairness on the facts of a particular case.
Well, then you're going to have to square that with the authorities, which haven't yet shown us the key.
Yes, well, I'm hoping to come to Mirage and Independent now. But if I can deal with the, I mean, this really attaches to the option of being able to appeal to the board. We accept that the Court of Appeal, of course, appreciated that there is only a right to make an application for special leave, and so that the board has that reference. It's the bundle 131, paragraph 21. But if the board refuses leave, as the appellants contended in their pre-action letter, then the mere right to seek leave from the board does not automatically translate to a system that is fair. And that, we say, seems relatively clear from the case of Hines. And if I could invite the board's attention to page 402. And it's looking at the head note for the moment. And this is at F, lettering F, page, sorry, 404, forgive me, my mistake. Of independent, sorry, wrong reference. Wherein looking at the process, in deciding whether someone's right not to be deprived of their liberty, except by due process of law, had been violated, it was the legal system as a whole which must be looked at, not merely one part of it. And in that case, where A had been able to secure his release on bail pending his appeal against conviction for contempt, his position was essentially no different from that of any other person convicted of an offence, since any shortcomings in the first hearing could have been made good on appeal. But of course, my lord, in that case, they were dealing with an appeal to the Court of Appeal. In this case, the appellants did not have that option. And so when looking at the system as a whole, if there is no remedy available domestically, that is to go back to the Court of Appeal, then we would say that the system as a whole should not be construed as fair. And if I could take the board to page 470 of the bundle. This is the decision of Maharaj. And it's at letter D, the somewhat famous dicta of Lord Diplock. In the first place, no human right or fundamental freedom recognised by the Constitution is contravened by a judgment or order that is wrong and liable to be set aside on appeal for an error of fact or substantive law, even where the error has resulted in a person serving a sentence of imprisonment. The remedy for errors of these kind is to appeal to a higher court. Where there is no higher court to appeal to, then none can say there was an error. The fundamental right is not to a system that is infallible, but one which is fair. And all of that we accept, except that in Maharaj, there was no appeal to the Court of Appeal. There was the option of applying for special leave to the board. And in Maharaj, they said that that doesn't render the system fair. Now moving to the appellant's position, we say that in this case, the appellants are in no different position, although factually there are differences, to that of Maharaj. Because in the circumstances where they had already exercised their right of appeal to the Court of Appeal, there was no higher court they could appeal to, save, of course, an application for special leave to the board. And if that was indicative of a system that was unfair, because in other words, you couldn't get a remedy domestically, then we say that that applies here. And no material distinction should be drawn with the appellant's case now before the board. Just dealing with...
Sorry, just before we move away from Maharaj, could you help me? I think you said that the board said that the option of appeal to the board did not make the system fair. I'm just looking
yes,
where that is
just, I think reference.
Yeah, it's paragraph 88 of independent publishing.
Do we have it in Mirage?
Take that one from Mirage, I think it's
So where is it in independent publishing?
it's 88, which is it's page 436.
My lord, I can't give you the reference in Mirage, but the extract that Mirage is dealt with in Independent, which is at page 436. And it may be I can put my hand on that section, that I can take the board to that. It's 436 C and D, where Lord Brown, in looking at that part of Lord Diplock's judgment in Mirage, it's the last sentence of paragraph 87. Of critical importance to its true understanding is that Mr. Maharaj had no right of appeal to the Court of Appeal against his committal, and equally therefore no right to apply for bail pending such appeal. And then in deciding whether someone's section 4A right not to be deprived of their liberty except by due process of law has been violated, it is the legal system as a whole that must be looked at, not merely a part of it. Fundamental right, as Lord Diplock says, to a legal system that is fair, where, as in Maharaj's case, there was no avenue to redress, save only an appeal by special leave direct to the Privy Council from a manifestly unfair committal to prison, then despite Lord Hailsham's misgivings on the point, one can understand why the legal system should be characterised as unfair. And that was the only option available to Maharaj.
Can I just ask one question? Could the board on a petition for special leave have granted bail, or would it have to wait until the grant of special leave?
I'll have to check. I don't know the answer offhand. One assumes that the board, because it has all of the powers of the Court of Appeal, would have the power to grant bail. The problem is here, you weren't appealing the sentence per se. You were simply saying you were entitled to have a direction.
Yes. All right. Thank you.
So we weren't complaining the sentence was wrong or manifestly excessive. And I would also add, my Lord Sales, that it's relatively unusual for the board to grant bail in criminal proceedings. I certainly am not aware of any case where it has done so. And where the sentence itself was not challenged, i.e. the 15-year sentence, it may be the board would not have entertained that application, but might have given, as sometimes the Court of Appeal Criminal Division does, an expedited hearing. Sorry.
Lord Hanvin has a question. And then Lord Leggett.
Yeah, the reason that Lord Brown was saying that the system was unfair in Maharaj was because at the time of Maharaj, there was no right of appeal at all at the Court of Appeal in respect to committal. That law had been changed.
Yes.
So Lord Brown says at paragraph 89, that makes it the same as any other criminal case. You have a right of appeal and there's no unfairness.
Yes, but I think the difficulty here, my lord, is that where you're dealing with a system which impacts on liberty of the subject, there has to be something available locally that can address that, because that is where the litigant or prisoner is. And I'm struggling to see, and I make this submission, that although the law was changed following Maharaj and Chukalingo, the circumstance that existed for these appellants were that after they had already exhausted their right to appeal to the Court of Appeal, there wasn't a further domestic remedy available, save, of course, the constitutional motion. And if that is right, then it is where it almost reverses us to the position that Mr. Maharaj was in, because he couldn't appeal to the Court of Appeal. He had no right to go there, just as these appellants didn't, to correct the anomaly.
So you had a constitutional right and a right to seek special leave, but you say the system's still unfair.
Well, we say it is still unfair, my lord, because if you've already exhausted your domestic remedies, as far as the appellate process is concerned, the most expeditious way to secure your release would have been the constitutional motion, which, as I say, incidentally, Mr. Maharaj had actually used to secure his release when Maharaj was decided many years ago. And yes, the application for special leave is there, and one assumes that it would have been granted, but that in itself doesn't, we say, render the system fair where the appellants had already been serving an excess period. The most expeditious way to get out, bar the position of the respondents, would have been a constitutional motion. Could I also invite the board to look at Hines, because
just before you do, I think Lord Leggett had a
sorry.
No, it's been superseded. Thank you.
Thank you.
One of the points that was addressed in Hines by Lord Bingham, and it's at page 402 of the bundle. In dealing with the facts, and it's paragraph 24, or a very different case of Hines, where he was trying to use constitutional proceedings to determine a matter or raise a matter that had already, it seems, been dealt with by the Court of Appeal in the criminal proceedings. But whatever the merits of that particular case, Lord Bingham went on as follows: it would be undesirable to stifle or inhibit the grant of constitutional relief cases where a claim to such relief is established and such relief is unavailable, or, this the important part, not readily available through the ordinary avenue of appeal. And so we're here the relief they sought was either unavailable, certainly not readily available. We would say that the issue of the constitutional motion procedure was both bona fide and the most effective remedy to secure their release. And if the Constitution is the living instrument we say it is, and Lord Bingham says it is, then it must be dynamic enough in our situation to have obtained the release of these defendants. And so that the board has the point, and forgive me for coming back to it, the appellants in this case were not trying to use the constitutional proceedings as a collateral attack on conviction or sentence. They accepted that the sentence imposed was correct. It was the procedural error, which one can raise in a constitutional motion, that they were primarily concerned with. And the distinction between procedural errors and substantive law, insofar as there is any material distinction, we say doesn't matter, but insofar as they needed to demonstrate an error in procedure, the failure to give a Section 49 direction was one. I would invite the board to look at Mirage again, where Lord Hailsham's judgment touches on this. It's page 481. Wherein at the very top of the page, this is B, dealing with the distinction between mere judicial error and due process and so forth. He says, I doubt whether the distinction, important as it may be intellectually, would be of much comfort to those convicted as a result of a judicial error, as distinct from a deprivation of due process, or would be understood as reasonable by many members of the public, when it was discovered that the victim was entitled to no compensation, as distinct from the victim of a contravention of Section 1 of the Constitution, who would be fully compensated. And we say that insofar as there may have been any residual distinction before constitutional relief can be granted from procedural error versus an error of substantive law resulting in a loss of liberty, we would say that that distinction should no longer be made. Sorry, I thought my Lord Briggs was asking. Can I?
I'm so sorry.
No, it's all right. Could I? Now, my Lord, where in this case, as I say, there was no good reason for the Court of Appeal to have refused to make the Section 49 direction. We couldn't. It should not have been construed, insofar as the courts below did construe this, as an abuse. They were seeking, as I say, their release as the primary remedy. But insofar as the respondents rely on independent publishing, and the courts below as a basis to say, well, the appellant's claim should have been construed as an abuse and the special leave process was sufficient. There are important distinctions to be drawn. And if I could invite the board's attention to page 436 of independent publishing. One of the observations made there, paragraph 89, as drawing a distinction, was that the particular appellant there, his position had become essentially no different from that of a person convicted of any other offence. Convicted persons cannot, in the ordinary way, even if ultimately successful on appeal, seek constitutional relief in respect of their time in prison. Now, we say that there is a material distinction between that case, and this may impact on what Lord Hamlin was asking me earlier, because in this case, although the conviction was safe and the sentence was passed, it doesn't appear, and it was never the position adopted below, that after June 2009, these appellants should have been in custody pursuant to that sentence. And so the situation here is different because they couldn't complain quite rightly about the sentence of imprisonment they had to serve to June 2009, but they don't make that complaint. And this is not a situation where the Court of Appeal or the Judicial Committee was being asked to reduce the sentence imposed. This was purely a failure in procedure. And so it is not the same as an ordinary criminal defendant who'd been convicted, who was ultimately successful on appeal. That wasn't the complaint in this case. And insofar as the appellant relies on Forbes, as I understand it, on this same point, I'm just looking at my time, my Lord. I'm going to try and wrap up. Could I invite the board's attention to the supplemental bundle that the respondent put in, and it's page 4. Where in relying on Forbes, the board's decision in Forbes, the summary is as follows at letter E. An accused who is convicted of an offence and sentenced to a term of imprisonment and who serves part of that term before his conviction and sentence are quashed on appeal is not entitled to redress for breach of his constitutional rights to due process and the protection of the law, save perhaps in an exceptional case. And where in the appeal before the board now, no complaint is made about the conviction and sentence. The complaint is about the failure to make a direction which should have meant that the sentence passed in law was the one they served and no more. That makes this case exceptional. My Lord, Lord Legate.
You keep on emphasising that your point is one of procedure, which obviously in a sense it is, but doesn't it go beyond that? Because the result of the failure to exercise the discretion wasn't it, on your case, that their sentence was in effect increased by 29 months beyond what it originally had been, without any rational basis?
Yes.
So it does go to substance as well. They served a longer sentence than they should.
It does, and I think we've tried to elide the two in our case, that it's procedural, but whether or not it's also substantial. But it doesn't mean, and cannot form a basis, which is ultimately what we come to, for denying the appellants the constitutional relief that they sought. And where by the time the motion was heard, the only thing that could be then provided was a declaration and compensation. Well, where the respondent never disputed they should have been in custody in the first place, then it should follow that the courts should have granted them that. And again, similar to Maharaj, who had served his sentence by the time his motion was determined. My Lord, the case of Bowler, we sent this to the board, I think yesterday, and forgive me that it was not put in the bundle. It should have followed after the board's decision in Bowler in the bundle, but it's a very short decision. It's 10 pages. Can I confirm that the board has that?
Yes.
Now, this was relied on by the appellants in the High Court and also in the Court of Appeal. The Court of Appeal took the view that this decision was wrongly decided. But it's interesting for two reasons. Number one, this was the motion for constitutional redress following the board's decision in Bowler. So after his appeal succeeded before the board, he then went to the High Court seeking constitutional relief. And if I can take the board to page 8, paragraph 19 of Bowler in the High Court.
I'm afraid I don't have this authority. Do you think it could be sent again to me?
Yes. Can we send that to the registry?
Thank you. It may have just not come to me because I wasn't listed on the case originally.
My junior, Mr. Hitchens, is going to do that now. Would your ladyship wish me to pause for?
No, absolutely not. Carry on. I'll make a reference and look at it.
Paragraph 19 of the High Court's decision in Bowler. This is a decision of Madam Justice Gobin. This is how she dealt with the issue. Section 49 is a peculiar section. It effectively allows additional loss of liberty in circumstances unconnected with a prisoner's conviction and sentence. The objective of withholding a direction is penal. Section 49, therefore, provides an additional safeguard against penalising an appellant unfairly, where it cannot be said that his appeal was unmeritorious. The consequence of a failure to apply Section 49 is automatic extension of a sentence of imprisonment or deprivation of his liberty. In effect, it penalised the appellant for exercising his right of appeal. She then rehearses that the claimant's release was only ordered after he'd been granted special leave, but then goes on. This too came only after he had already served 3 months in excess of his sentence. It was already too late to effectively and completely put right the consequences of the procedural error of the Court of Appeal. She then applies the reasoning of Lord Diplock in Maharaj and refers to a European case of Monell, where what it comes to is that she found that brought the case within Section 14 of the Constitution, the constitutional motion procedure. The minority in Monell observed that it's entirely possible that the time lost may comprise the entire period spent in custody between conviction and rejection of an appeal. And that's what happened to the appellants in this case. This is an extreme consequence which underscores the importance of affording an appellant proper due process under Section 49. The severity of this result is not diminished by a comparison of the conditions under which remand prisoners and convicted prisoners are kept. Remand conditions are notoriously appalling and unacceptable. The claimant may well, had the JCPC not made the order that it did, have served a further 10 months in custody.
Mr. Baharlal, you're into borrowed time.
Yes.
I won't shut you down immediately, but it may have to come off any time you would otherwise have in reply.
My Lord, can I invite the board to look at the decision of Bowler? The short point is that we say that Madam Justice Gobin crystallised the law on this subject correctly, and that she granted Bowler constitutional relief, in that case, a declaration and compensation, because she accepted that his claim was made out for the reasons or additional reasons that we have made to the board a few moments ago. Can I also deal with another matter, and it goes to the right of appeal to the board, even if it was suggested that they could have appealed a first time if they hadn't before, or a second time if they had.
Well, only at the expense of your reply time.
Yes, I'm happy to give it up. And it's page 383 of the board's decision of Hamilton, which really emphasizes the timelines. And there's no criticism about this and no doubt about it. It's 383 paragraph 15. The board, being very familiar with the delays that come from Caribbean states, said this: the board has no intention of departing from the direction Rule 11.2 of the 2009 rules, that an application for permission to appeal must be filed within 56 days from the date of the order or decision of the court below, or the date of the court below refusing permission to appeal. And I only draw that to the board's attention because by the time, even in 2006, the decisions of Ali had been given, the appellants in this case would have been well out of time for any criminal appeal. And finally, my lord, is this, and I deal with this shortly, although we say that this is perhaps the most important point. Absent the state of Trinidad and Tobago creating a slip rule where these matters can be corrected, we would say that where the Judicial Committee is primarily concerned with points of law of general public importance, it should not be called upon to effectively become a slip rule court to correct errors that come from a failure of the Court of Appeal to give a Section 49 direction. That, we say, devalues the right to apply for special leave, and where the board had already determined the issue in Ali and Bowler, it should not have been necessary for the appellants to exercise that right where there would have been no dispute and was no dispute. They should have been released. And that may be an important point that the board would wish to consider, because the board's decisions were binding and there was no reason for them not to have been put into effect in the motion, which it could have been. My lord, that's 12:36. I'm 6 minutes over my time. Can I stop there and deal with anything in reply?
Thank you, Mr. Baharilal. Now, Mr. Poole.
My lord, my lady, I'm grateful. If I can perhaps start my submissions with some common ground. It's common ground that had the Court of Appeal exercised its discretion under Section 49(1, in line with the board's guidance that came some 5 years later in the Ali case, and then later the Bowler case, the appellants would in all likelihood have been released in June 2009. It is also common ground that where the complaint is that the appellants were deprived of due process as a consequence of judicial error, as here, it is the legal system as a whole that must be examined to ascertain whether it can be characterised as fair and whether there's been a denial of due process. And that's the principle that the board has from Lord Brown's judgment in the independent publishing case. And it's paragraph 88 of that judgment, which is at 436 of the electronic record. And what the appellants are entitled to, as Lord Diplock put it in Maharaj No. 2, is a legal system that is fair, not one that is infallible. And that's electronic bundle, page 470, paragraph E of Maharaj No. 2. And perhaps let me start by also saying, goes without saying, it is obviously unfortunate and regrettable that the appellants served 29 additional months in prison. However, as the Court of Appeal held, that is a manifestation of the fact that the legal system, though fair, is not free from error. And the Court of Appeal in this case, and in the earlier case of Wren and the Attorney General, which is at 326 of the electronic bundle, and I will come back to that because it considered an almost identical issue. Both Court of Appeals held that the right to appeal to the board with special leave under section 1093 presented the appellants a fair opportunity to pursue redress and secure their release from prison, such that they were not denied due process. And my overarching submission is that the Court of Appeal did not fall into error when making that finding. It was a finding open to them on the evidence, and it is a finding in my submission that is plainly correct. And we know from the decisions in Ali and Bowler, and also indeed several other cases, that had the appellants applied for special leave to appeal to the board, the Court of Appeal's error would have been corrected before they began to serve any part of their sentences attributable to judicial error, in my submission. And the board will possibly have seen that in all cases since Ali, the state has always conceded the point, as it did, and we know it did, in Bowler, and you've been taken to the passage where Mr. Guthrie conceded on behalf of the state. Now, I propose to begin my submissions by addressing what I see as the core complaint, and it's identified by the appellants at paragraph 9 of their written case, which is page 163 of the electronic bundle, where they say the appellants now appeal to the board on the basis that the courts below failed to properly assess the legal system as a whole, since it cannot be characterised as fair, that ultimately the only effective remedy was the appellant's constitutional motion seeking their immediate release, declaratory relief that their rights to liberty, security of person were breached, and compensation. What I say that claim essentially boils down to is a contention that these appellants were denied due process because it is said an appeal to the board by way of special leave is not an effective remedy for prisoners in their position following an appeal to the Court of Appeal. Now, the respondent's answer to that, it's set out in our printed case. It's really sections E and F that respond to this particular complaint, which are paragraphs 27 to 36. What I propose to do is distill those submissions into 3 points. And if I may, I'll just summarize those before developing them. My first point is a denial of meaningful access to justice is not an argument that is now open to the appellants on an appeal before the board, because that is not how the case was argued in the courts below. And that point is made in our written case at paragraphs 27 to 30. And when I develop those submissions, I'll refer the board to a well-known case of Baker and the Queen, which I apologise, hopefully has found its way to the board because it's not in the electronic bundle, but it's a well-known passage of Lord Diplock explaining the practice of the board is not to normally allow new arguments to be run before them for the first time. But as I say, I'll develop that when I develop those submissions. The second point is that I say the evidence relied on by the appellants to make good their argument that they were denied meaningful access to justice is at best inconclusive, and at worst, in my submission, points the other way. It is certainly not reliable or persuasive enough to lead the board to disturb the finding of the Court of Appeal in this case, and the finding in the earlier case of Wren, that the legal system in Trinidad and Tobago, when viewed in the context of a complaint of failure of due process by way of judicial error, is fair. And then my third point is that accepting an application for special leave can be a somewhat protracted affair, as has been held by the board in a number of cases. That right remains an effective right and an effective remedy. And access to justice remains meaningful in my submission and substantive, however great the difficulty in practice of accessing it may be. And in that respect, I'll take the board to what Lord Bingham said in the, again, well-known case of Hines at paragraph 19. So if I may develop those 3 points, and the first point then why I say it's not open to the appellants to complain about a denial of access to justice. We say at paragraph 28 of our written case, which is page 191 of the electronic bundle, that upon issuing their constitutional motion, the appellants submitted no evidence of and made no submissions about their inability to access legal representation, either due to custodial conditions or means. And the High Court made a finding at paragraph 18, and if I can ask the board to turn up paragraph 18 of the first instance judgment, which is at page 91. Mr. Justice Harris, at paragraph 18, made a finding that due process, and in this context, the ability to appeal from the Court of Appeal to the board by way of an application for special leave, was available to these appellants. Now, the appellants did not put in any evidence or advance submissions in the Court of Appeal suggesting that a lack of representation meant that they were in practical terms unable to appeal to the board. We have the appellants' written submissions. They're at page 101 and they run through to page 119 of the electronic bundle, the written submissions before the Court of Appeal. So we know the shape of the argument. And importantly, and it's a point that the board will be alive because of my interruption of my learned friend's submissions at the start of the morning, there's an important concession in my submission, and it's paragraph 12 of the Court of Appeal's judgment is where it's recorded at page 126. And Mr. Thompson remains involved in the case. Mr. Thompson represented in the Court of Appeal. Mr. Thompson wrote the pre-action letters, and Mr. Thompson's name appears as a signatory to the printed case before the board. And what is conceded, and I say it is plain, the concession that is made, is that these appellants could have applied with special leave to the board and did not attempt to do so. And furthermore, what we know, and if we look at paragraph 21 of the Court of Appeal's judgment, a bit further on, page 131 of the electronic bundle, the Court of Appeal record that it was not argued by the appellants that they could not have appealed to the board and had that appeal determined before they began to serve any portion of their sentences that could have been attributed to the error of the Court of Appeal. These are key findings and are based on concessions that the appellants cannot now seek to go behind, certainly cannot seek to go behind without any evidence. And as I've said, we know the arguments that were advanced because we've seen them in writing. There was no argument advanced by the appellants in the Court of Appeal that a lack of public funding for appeals to the board or practical difficulties in mounting an appeal meant that the legal system in Trinidad and Tobago was unfair and there'd been a denial of due process. The grounds of appeal to the board did not make those arguments. We've got the grounds of appeal to the board at 145 of the bundle. Sorry, my Lord Legate.
How much should we look at the system overall in considering this question, and how much in relation to the facts of this particular case? What I have in mind is that here the sentence was for 15 years, so maybe said they had quite a while to try and sort out the problem. In another case, it might have been a few months, let's say, the sentence, and by the time an appeal to the board had been lodged and so forth, the sentence would have been served. I mean, one argument made against you is that the remedy needs, if it's going to be effective, it needs to be capable of operating speedily. If it's simply an oversight, which you accept, that results in a failure to start the sentence from when it originally started, unless you can get redress quickly, It's useless, isn't it, in many other cases? Maybe not in this case.
My lord, in answer to your question, I say you obviously have to look at the legal system as a whole, as set out in the independent publishing case. But you obviously have to look at the legal system as a whole, as applied to the individual facts of each case. And the question is, can meaningful redress be achieved in the context of the particular individual's custodial sentence? And if the answer is yes, then there has been no denial of due process. So take Mr. Ali's case in the independent publishing case. The answer was yes, because he could appeal to the Court of Appeal and secure his release on bail within 4 days of his committal. In the present case, the answer is yes, because the appellants could have ensured they served no additional time in custody by appealing to the board. And that's when I, a bit later on in my submissions, take you through the Court of Appeal's decision in the Wren case, which mirrors very much the Court of Appeal's decision in the present case. That is the ratio that you derive from the Court of Appeal of Trinidad and Tobago, and I say that is a correct application of independent publishing. Just to finish the first of my three points, having, as it were, laid the groundwork for why I say on the facts it's not open, and I said I take you, my lords, my lady, to the case of Baker. It is page 788 of Lord Diplock's speech in Baker at little b, where Lord Diplock says, in any consideration of the binding effect of a decision of the board of the Judicial Committee, however, it is important to bear in mind that its normal practice is not to allow the parties to raise for the first time in an appeal to the board a point of law which has not been argued in the court which the appeal is brought. Exceptionally, it allows this practice to be departed from if the new point of law sought to be raised is one which, in the board's view, is incapable of depending on an appreciation of matters of evidence or of facts of which judicial notice might be taken, and is also one upon which, in the board's view, they would not derive assistance from learning the opinions of judges of the local courts upon it. Now of course, here, my learned friend is right that my lords and my lady can take some judicial notice of, for example, findings that were made in cases like Hamilton and Lewis as to prison conditions in Trinidad and Tobago and in other Caribbean countries, and the practical difficulties that presents, in particular to non-capital prisoners prosecuting appeals to the board. But what I also derive from Baker and the Queen is the last part of what I've just read out of Lord Diplock's speech, which is, when one is talking about a complaint about a denial of access to justice or a denial of public funding to allow representation after a Court of Appeal determination, that is an issue where it would have been of great assistance to the board, in my submission, to have had the considered views of the judges of the local courts, who will be well acquainted with the local legal system and the ability of prisoners to seek redress by appealing by way of special leave to the board. And we also know, through the cases such as Ali, Tawari, and Bowler, that a number of prisoners, non-capital prisoners, are able to seek meaningful redress by making applications for special leave to appeal to the board. So for those reasons, I say, first and foremost, this argument about denial of meaningful access to justice is not one open, or not one that should be open to the appellants now. My second point, though, is the evidential foundation for it. And we make the point in paragraph 31 of our written case, where we draw out a number of inconsistencies. Sorry, that's page 191 of the electronic bundle, paragraph 31. We identify three, what I've described as internal inconsistencies in the appellant's case. And really those boil down to that we know that the appellants were able to obtain representation and issue a constitutional motion whilst still in custody. There is no evidence that the appellants' legal representatives were or are acting pro bono. In this regard, obviously we know that they were, prior to their convictions, both employed as police sergeants no evidence to suggest that they were without the means to pay for legal representation. And the pre-action letters suggest that the appellants were aware of their right to appeal by way of special leave to the board. And specific reference is made to Mr. Bowler. And I'll come back to Mr. Bowler in a moment, because Mr. Bowler's case is quite important to these appellants. There's also, I suppose, the point that the High Court note, and it's noted at footnote 8 of their judgment at page 93, that there's no evidence that the appellants were unrepresented at their appeal in the Court of Appeal. Now, these are all points that can be addressed by these appellants and in evidence, obviously. But what is perhaps quite telling in my learned friend's submissions is that there's been a lot of reference to what is in evidence, but the board has not been taken to the evidence, because there is evidence in this case. It's two affidavits, an affidavit from Mr. Duncan, an affidavit from Mr. Jokhan. And that is the affidavit on which they base their constitutional claim and their claims for relief. And what they say in their affidavit, and they are, for all material purposes, identical. So for ease of reference, I'll take you to the first one that appears in the bundle, which is Mr. Duncan's. And it's page 11 of the electronic bundle. Actually, sorry, if I can take you to the page before that, page 10, to put it in context. They say, or he says, I know Mr. Bowler, a former police constable. He was in prison with me. He was convicted of the offence of demanding money with menaces on the 19th day of October 2001 and sentenced to a 6-year term of imprisonment. Mr. Bowler appealed his conviction and sentence to the Court of Appeal, which on the 19th of July 2004 dismissed his appeal. Paragraph 20, Mr. Bowler appealed the decision of the Court of Appeal to the Judicial Committee of the Privy Council, and then by a judgment of 30th of January 2006, which, just pausing there, I think we know was delivered on 8th of March 2006. The Privy Council dismissed Mr. Bowler's appeal, but ruled time spent in custody, awaiting hearing determination, be counted towards his sentence, ordered he be released immediately, whereupon officials of the prison service, being servants of the defendant, released Mr. Bowler. So that is the evidence of, and it's, as I say, identical in Mr. Jokhan's affidavit as well, that they served time, they're in prison with Mr. Bowler, and they knew precisely what was going on with Mr. Bowler's case, and that Mr. Bowler had appealed by way of special leave to the Judicial Committee and had been, as a consequence of that successful appeal, released immediately. And if I may, just before we move away from Mr. Bowler's case, just ask the board to look at page 318, which is the JCPC judgment in Bowler and the state, just to identify some salient facts, and they all really appear in paragraphs 1 and 2 on page 319. This was a non-capital case where Mr. Bowler was sentenced to 6 years imprisonment, so less than half the appellant's sentences. December 2002, the Court of Appeal dismissed his appeal and made no section 49(1) direction. Special leave to appeal was given in July 2004, so that's within 19 months of the Court of Appeal's decision. And then the appeal successful in January 2006, and successful in respect of conviction, and at the same time special leave given to take the sentence point, which, as we know, was conceded by the state and led to Mr. Bowler being released, presumably when the board handed down its judgment on the 8th of March 2006. So it's just over 3 years from the date of the Court of Appeal decision to the judgment of the board and Mr. Bowler's release. So as at, in my submission, March 2006, both appellants were plainly aware that they could appeal. Sorry, my Lord Legate.
This may be something to ponder over the adjournment, but can a system really be said to be fair if, even though you may have had a chance to appeal at the time, if you only realise later that your sentence did not take account at the time pending appeal, and that it should have done, the answer is you've missed the boat, which was what is said in this case. You're now locked up for the last part, and there's nothing to be done about it. Is that a fair system?
Well,
Mr. Paul, you've got a minute to answer, or you can think about it over the short adjournment.
well, my lord, my answer won't be different, but it might be better expressed after lunch. But I can give the short answer. I can give the short answer, which is the system is fair because it is the effective remedy, namely the application of special leave to the board, that renders the system fair. And as I think, in fact, the Court of Appeal, certainly in Wren, and I think, although I'll check this, in this case, found effectively, I think it was, yes, sorry, it was the Court of Appeal in the first instance judge, sorry, in the present case, cited a case called Noel Phillip, and it's at page 92 of the bundle. And at paragraph 23, which is page 93, he makes the fair point in my submission, which is addressing Lord Legate's point. It did not matter in that case that Mr. Phillip was unrepresented.
But sorry, well, perhaps you can answer after lunch, but is it fair because you had your chance but missed it? Or do you say it's fair because you can still appeal now, even many years out of time, to the Privy Council, and that affords you an effective remedy, even when you're stuck in prison time, when you should have been released? Or is it a combination of the two that somehow makes it fair?
Well, take your time, Mr. Poole, unless you're desperate that we should think about your short answer while we're having lunch. But for my part, I'm very happy to wait until 2 o'clock.
I thought in that case, so am I. I'm happy to give the answer later.
Very well. Well, we'll adjourn till 2 o'clock. Thank you very much.